Hello viewers, welcome to our channel Rising Legal. Today in this private international law class, I am going to discuss an important topic, that is characterization and its theories. Before going to detailed discussion about this topic, at first we try to understand what is the meaning of the term characterization. Viewers, the characterization is also known as classification, and characterization is one of the important elements in the understanding and decision making in a dispute having a foreign element to it. The issue of characterization is one of the most complicated problems of private international law. Complexities owing to the intersection of the rules of various countries in regard to the private international law. So viewers, the concept of characterization in private international law could be addressed in three stages. Number one, the complexity of the problem or methodology involved in a characterization. Number second, the theoretical statement explaining characterization. Number third, the process of characterization. So in a case containing a foreign element, the English court would have to examine various issues in a sequential manner. Firstly, there is a determination of the jurisdiction presence of the English court over the parties to the dispute and the cause of action in that dispute. Having satisfied itself that it possesses the jurisdiction over parties and the cause of action, the court proceeds to address the judicial nature of the question that requires the decision. Now viewers, I am going to the next page of that particular topic, that is theories of the characterization. Actually, there are four theories to explain the concept of characterization. They are: number one, characterization should be governed by lex fori. Number second, characterization should be made under lex causa. Number third, it should be made under two stages. One, primary characterization based upon lex fori, and second is that secondary characterization made under lex causa. Number four, characterization should be based on comparative law and analytical jurisprudence. So now I am going to detailed discussion of that particular theories. So regarding characterization, first theory is that characterization based on lex fori. Viewers, lex fori is a Latin term which means the law of the forum. It is a choice of law rules. It simply means the law of the country in which an action is brought. The theory of lex fori was first proposed by the German and French writers Kahn and Bartin in the year of 1890. It is a prevailing theory which has been adopted and implemented by the English court as well. So viewers, lex fori theory or law of the forum is a way to tackle the problem of the characterization. The theory of characterization regulates the problem of conflict of the laws. The theory of the characterization allows a court to choose which law will be applicable in a particular issue. Until and unless the same is settled with, it will be impossible to apply the appropriate conflict of the law rules. So viewers, this theory suggests that a particular issue should be characterized in accordance with the own domestic laws which are applicable, as well as the foreign rules of law in accordance with their nearest and closest domestic law. So when a case comes to the court applies domestic laws if the elements involved are domestic. However, when foreign elements like domicile are involved, the court must consider three main things. First is that whether the particular court has the jurisdiction to try the case. Number second, characterization of the issue. Number third, choice of law to be applied in the issue so characterized. So the argument of Bartin in favor of the lex fori theory is that the courts as well as the judges are bound by oath and to the duties of their own legal system and no one else and can therefore only administer the same. Now viewers, we actually try to understand what are the exceptions to the lex fori theory. Actually, there are two main exceptions to the rule of characterization that is to be made on the basis of lex fori. Number one, lex situs. What is that? The applicable to either movable or immovable properties. Thereafter, lex loci contractus. What is this? The applicable in cases of contract by correspondence. Now viewers, I am going to discussion and another important topic, another important theories of that particular discussion, that is the characterization. That is characterization on the basis of lex causi. Lex causi is a Latin term which means law for the cause. In conflict of the laws, is the law chosen by the forum court from the relevant legal system when it judges an international or interjurisdictional case? That is the issue on that particular theory. It refers to the usage of a particular local laws as the basis or cause for the ruling, which would itself become part of reference legal canon. Once the forum court has ruled that it has jurisdiction to hear the case, it must then decide which possible law is to be applied. If the parties and the cause of actions are local, the court will apply the lex fori, the prevailing municipal law. If there are foreign elements to the case, the forum court under conflict of the laws will consider which law will apply. Now viewers, the next theory of the characterization is that twofold classification theory. What is that? There is a primary classification based on legal fori and a secondary classification that is based on lex causi. The reason for the expanded meaning is that for the purpose of deciding the legal category allocation, the judges must have a wider choice than just an internal law alone. So viewers, there are two exceptions for this rule. First is that dispute regarding issue of movable and immovable should be governed by the lex situs. Number second, where there are situations of the possible two foreign legal system applicable and they present similar characteristic, then the court should adopt their common classification. Now viewers, another important theory of characterization is that is comparative law based on characterization. Juris Rebel and Beckett were the proponent of this theory. They suggested that the characterization ought to be founded upon analytical jurisprudence and on the basis of comparative study of laws. According to Beckett, all cases fell into three categories. First is that cases not involving characterization of a rule or institution of internal law. In these cases, characterization is based on the principle of lex fori. Number two, in most cases, the courts would have applied the rule, statutory or common law of its internal law. Number third, for cases involving characterization of the rules or institution of foreign internal law, that means the court must not only ascertain the rule of that internal law, but also understand the circumstances under which such rule has been applied by the court. So viewers, that is our today's discussion in your private international law, that is characterization and various theories of the characterization. Hopefully you understand the subject matter clearly. Thank you very much. Thank you very much for watching our channel Rising Legal. Thank you.